they're ethical and they don't screw up as often as the FBI, as you know from Washington, Pappacoda, etc. He then went to law school at Nova. He was one of my students. It won't surprise you to hear he was a brilliant student. What's the other thing?
Surprising me.
He interned in the Broward State Attorney's Office, and then he worked for them for 18 months. After that, he was a statewide prosecutor. And ever since then, he's been in private practice. He does mainly civil work, a lot of fraud work, but also criminal defense. It's unlikely that any of you or any of the other students here will kill someone and rob a bank. I mean, more likely when students get in trouble, it's because they possess unprescribed pharmaceuticals, or they have too much fun with fermented material, and as a result they get arrested. He's the name I would give you and his phone number. If that should happen, of course, you and I know it won't happen to any of you, but you have friends in the other sections. So with that, he's going to tell you about a case that he worked on, and he's written a couple of articles on this topic, which ultimately I will send to you. So without further ado, Joe Pappacoda.
Hi, everybody. I had Randolph for a couple of classes in 1989 and 1990, which is before most of you or all of you were born. And before I get started, I want to tell you a little funny story about Randolph.
That wasn't part of the...
We were in a trial advocacy class, and here I am in Randolph's trial advocacy class. And of course, I come charging in the open. I've got a little bit of law enforcement background. And, all right, so I'm a little cocky. So he's telling us, you know, this is the trial, these are the facts. And first day, like the first day of class, he wants to volunteer to do a closing argument. I'm like, I got this. So I stand up there, and he's somewhat nervous, but I stand up there and I give my closing argument, and of course I don't know what I'm doing. I'm not arguing the issues, I'm arguing law, which is really undisputed, and I burned up all my time. I totally bombed it. So Randolph immediately stands up and says, and this was in the ad drop period, I just want you all to know that if you give a closing argument like that for a final, you will get an F from me. Okay, so I sat down and I'm like, oh crap. 4 or 5 people dropped the class right there. Boom, out. And that's a true story. This is one of the most important classes that you can have as a lawyer. And I want to tell you briefly why I believe that's true. There are a lot of professors here that will tell you legal research and writing is the most important class, 2 credits. It is important, but not as important as this class. And I'll tell you why. If you can somehow manage to get out of here with a B, B plus, or an A, or an A minus, you will know more about Florida attorney ethics than the people at the Florida Bar attorney hotline that in the last 26 years I've called them about 3 times. And what I found is that you cannot rely upon that as, I don't have to worry about this class. If I get into a problem, I'll call the Florida Bar and they'll tell me what to do. No. You're going to be more of an expert on attorney ethics than the people picking up the phone at the Florida Bar hotline. So that's just a little caveat. This class is really, really important, not only for your ability to make more money, but your ability to stay out of trouble, your ability to counsel others, your ability to see other attorneys doing something wrong. All of these things are ultimately going to result in your ability to make more money because you know the right way. In certain situations, you can use ethical violations right in your pleadings. It is a source of law that you can use in your pleadings at different points in time, and it really does slide right into the Florida statutes and into legal arguments and case law. So don't just sit here and say, well, this is regarding my conduct and what I do right and wrong. You're looking at the other attorneys, and you can use it. If they're violating the rules, you can use it against them and ultimately win. So it's really important. So anyway, I forgot what you gave me right up, but I want to say maybe a B plus or something like that. All right, so I want to tell you about a case. I've been doing criminal defense work since 1997 and have been on the Broward County court-appointed wheel since then. Probably had about, I can't even tell you, 3,000 cases. Can't tell you how many trials I've had, but I'm also on the capital murder wheel for Broward County, which is very difficult to get on because of the requirements that you have to go through to get on it. And there's about 28 people, 28 attorneys on the capital murder conflict counsel wheel in Broward County. So here's the factual scenario. We're dealing with a Nova professor by the name of Jim Morrissey that's murdered. Murdered in his home in Plantation, Florida. Very messy murder and crime scene that involved an assailant coming into his house. He was asleep on the couch. His wife and minor adopted son, who was 5, were asleep in the bedroom. This is about 10 o'clock at night. The lights are on, everybody's sleeping. The assailant comes through the front window, jalousie window, and takes the couple and puts them in the bedroom and ties them up with wrist ties, the plastic wrist ties from Home Depot. The assailant is a young man in his 20s and potentially cracked out when this is occurring. And then things get a little bit weird because the assailant just decides that what he wants to do now is to get everybody into the car, drive to the bank, go to the ATM machine, and take out all the money in the bank account. They drive to the bank, and Jim Morrissey is in the front passenger side of the car. The wife is driving the car. No, I got that mixed up, sorry. Jim Morrissey's driving the car, the wife's in the passenger side, and the assailant's in the back with a gun. And Mrs. Morrissey goes to the ATM, and she can only pull out $500 because, as you know, there's certain caps on how much cash you can pull out on a daily limit. They go back in the car. They end up driving back to the house. Mrs. Morrissey and the son end up back in the bedroom with, like, their heads are covered and the plastic ties are on. She's in the bedroom with her minor son, who's 5 years old. Mr. Morrissey's in the living room in the kitchen area, and he's tied down to a chair, strapped to a chair, and essentially what happens is try to shoot his head with the gun. It misfires. Now keep in mind there's only one assailant here that we know of right now. Gun misfires. Out comes like a Bowie knife kind of knife, and the assailant starts slashing Professor Morrissey and essentially kills him with the knife. That's not good enough. The assailant goes in the garage and gets 2.5 gallons of gasoline, comes back to the kitchen, and pours it all over the crime scene, lights it on fire, and runs away. Okay, this case is all in the newspaper, television, international, for a long time. I'm sure some of you may want to look at it online. You can, it's all there. So the assailant leaves, and he goes back to Gator Tint. Gator Tint is a tinting business over here, all also in Plantation, I think it's Plantation, off of Peters Road. And it's met by his father, Randy Tunador. So you've got a Randy Tunador Sr. and a Randy Tunador Jr. And for everything we know right now, Jr. is the assailant, the murderer. Okay. He meets his father at night at Gatorton, and his father goes ballistic and says, "What did you do?" The son comes in there, he's got a fist full of cash and a pile of cocaine. So Dad takes all of this stuff, he brings it in the backyard, and he lights a bonfire at Gatorton with all of his things in the bonfire. Son takes off, and he's at large. Okay, so now within a matter of hours, the police suspect that they know this is the Tunadors that did this. And the reason why is because the Tunadors were renting an apartment or a townhouse from Mr. Morrissey. They were having a landlord-tenant dispute, and Mr. Morrissey was going to evict the Tunadors, and this is the only thing that Mrs. Morrissey can think of that is a catalyst for someone that hates. The police will always ask, is there anyone that hates your husband? So this was the only thing that comes to her mind. So within a matter of hours, Plantation Police Department is on the Tunadors, like 2-3 hours, very quickly. And so the scenario is Randy Tunador Jr. goes to Beverly Hills Cafe for lunch, and he's spotted, and he's arrested. Okay, just give you a little factoid here that we don't know this at this point in time, but eventually the police will learn that Randy Tunador Jr. has high velocity blood splatter, like totally on his body, in his shirt, pants. This high velocity blood splatter in a black t-shirt that's not visible with the naked eye. So he's definitely at the crime scene. An attorney gets involved, and we'll call him Jim. Jim gets involved and decides he's going to represent Randy Tunador Jr. because Jim has known the family for years. Jim has represented both Junior and Senior in the past, and Junior's arrested for capital murder at this point. This is day one. Jim gets involved, and he's on the press, he's in the news, and he's like, he's going to represent Junior. At this point in time, I'm not involved yet. At this point in time, Gatorton has been frozen with a search warrant for 24 hours. The next day comes 48 hours. The police have the crime scene on the search warrant, but they're not releasing the crime scene. I get involved in the case because Jim comes to me and says, Randy Tunador Sr. wants the police off his premises. He's losing money. I'm like, okay, not a big thing for me, but you know, I'll shake up the police a little bit and say, look, you've been here long enough. Take your crap and get out of here. You next guy's got to run a business. So I get involved in the case. I go and meet with Randy Tunador Sr., who is an enormous fellow that has got a cast on his leg. He's hobbling around. He can't hardly even move, and he needs knee surgery, and he's popping oxycodone pills like hell. What happened to you, Mr. Tunador? Well, the landlord didn't fix the light switch at the top of the stairs because the prior tenant had a Rottweiler who literally ate off the switch where you click the switch on and off. The dog just ate it right off the wall. And so he couldn't put the light on. He fell down the stairs, and he's 350 pounds, all messed up. I'm like, okay, well, he doesn't look like a murderer to me because He's all messed up. The assailant went through a jalousie window this big, and there's no way in hell he's going through a jalousie window that big. I'm like, okay. So I get involved in the case, and I'm representing Randy Tonador Sr. Fair enough, right? Senior denied everything about the murder, being at the crime scene, just denied it flat out. Like, I was a Gator 10 shop, my son did this, okay? So already you're kind of getting the, having a landlord-tenant fight with the father, the son who's in the 20s goes and commits a murder. This just doesn't really seem right to me. But Senior's position is no. I'm not there. You're not going to find DNA, fingerprints, photographs, witnesses. I'm at the shop. I swear to God, this is not me. And Senior goes on Channel 7 and tells the world the same thing that I just told you. And he wants to support his son. He doesn't know what's going on. All over the TV loved this case and the news. I have to give you a separate set of facts on a little tiny case that's going to play in here so that you understand when I talk about the gun later. Before this homicide, you look very shocked. Are you okay? You want me to back up a little bit? Okay. 3 weeks prior to the murder. Are you all right? Yeah. 3 weeks prior to the murder, Randy Tonador reports his F-150 stolen from Gator 10. And it's stolen. And the F-150 was worth like maybe $3,000, but somehow magically the F-150 had $15,000 worth of radio equipment in it. And somehow magically, again, there was photographs and invoices for the $15,000 of equipment that was in it. And a little Saturday night special was in the truck. The whole thing was reported stolen. The truck was later found on 595 with the windows smashed out, and of course there's no stereo equipment in it. So, the police believed that this was insurance fraud, and they believed that the whole thing was staged, because why do you put $15,000 worth of equipment in a truck that's worth $3,000? It just doesn't make any sense. But the police didn't care about that. Okay, this came about after they got involved in the homicide case. They found out about this insurance case, but they really didn't care about the insurance fraud case. And I spoke to the detective and said, look, are you going to arrest them for insurance fraud? And they basically didn't care about the insurance fraud case, but keep it in the back of your mind, everybody believed it was an insurance fraud case, and everybody believed that it was staged. And the caveat here is the Saturday night special, which happens to be the operative gun that misfired at the crime scene. People believed that it was the Saturday night special that was stolen in the truck 3 weeks earlier. Okay, you got that? So, get back in line. Okay, so I think I left off where, at Gator 10. The police have custody. Junior's in jail. He's the primary suspect at this point because Mrs. Morrissey and everybody that was there that survived this. Oh, I forgot to tell you, Mrs. Morrissey was able to untie her hands with the assistance of her 5-year-old son, who grabbed a scissor, and she broke free when the kitchen was on fire burning with the gasoline. She broke free, got her son out of the house and essentially drug her husband out of the house while the house was ablaze. So she's a witness. She can positively identify Junior. Fair enough? She can't place Senior in the house. She can't, that there was no testimony or allegation that this 300-pound dude was in the house. She just knows this young kid doing all this other stuff. Are you with me? The police wire Randy Thunderdor's other son. They wire him and put him back into the family because it's such a dysfunctional family. You've got sibling rivalries in the family. And here we are, real time, 2 days after the murder, you've got yet another sibling who is voluntarily getting wired by the plantation police, voluntarily to go in the house and get evidence against his father because he's trying to protect his brother. Got that? His half-brother. He's wired. There's some evidence that Thunderdor's happy that Morrissey got murdered. He got what he had coming to him. Things of this nature, but nothing where it would indicate that Senior was either the murderer or orchestrated this, or nothing along those lines. It's like, hey, he's dead. I'm glad. He messed with the Thunderdor family. He was going to affect us anyway. Great, I'm happy. Please get this. Here we are, 3 days later. Here's the day before Randy Thunderdor was arrested. It's a Friday. I know it's a Friday because we had ballet tickets for it. It's a Friday. That's Carrie, by the way, over there. Friday morning, I'm met in the front of my office by Jim. And here's the statement that Jim tells me, pretty much verbatim. Is it right to swear in this tape right now?
I'm sorry?
Is it okay to swear?
Absolutely.
Okay. Joe, I fucked up. I hope the police were not up on a wire. I talked to Randy last night, meaning Randy Thunderdor Sr., and Randy said to me, Jim, you're not going to believe this. The gun that was reported stolen 3 weeks ago, I just saw it in my closet. I can't believe it. It's in my closet. And I told him, Randy, you can't have that gun in the house. You have to get rid of that gun. That's the statement. I'm looking at Jim and I'm like, why am I hearing this? As you would be. Why am I hearing this? Because he represents Junior. He's talking to Senior. Now he's telling Senior's attorney what he told Senior to do. When Senior hung up the phone with Jim, Senior commenced to taking the gun apart, putting the gun, because don't forget, Senior's not ambulatory, can't leave the house. He's like doing this kind of, he's really in pain, he needs knee surgery. Senior starts taking the gun apart, pulling out power tools to deface, destroy, put holes in the gun with drills, and there's another witness in the house, Hilda, who is Randy's significant other, if you want to call her that. She's listening to all this bang and chop. Okay, so that gun, which incidentally was ancillary to this homicide to begin with, because the cause of death was knife wounds. Okay, that was the gun that misfired. The gun gets chopped, taken in parts and pieces, and like shoved all over the house, poke a hole in the drywall, throw some parts in there, go up in the attic, throw some parts in there. The gun was like all over the house. Here comes the police. Not yet. So that phone call with him happened Thursday night. Friday, I hear the statement from the attorney. The police are still at Gator Tip. They're not giving up the crime scene. And I am not feeling good about this. And I go and meet with Mr. Thunderdor at 5 o'clock on a Friday afternoon. And here's what I tell Mr. Thunderdor. Now, you're in an ethics class, okay? There are ways to tell someone something ethically, and there are ways to tell somebody something unethically. And depending how unethical the statement is to that person, it may or may not be criminal on top of it. Got that? So I go there, and Thunderdor is sitting there, and he's popping oxycodone pills like a bat out of hell. And he ate 12 blues, 30 milligram oxycodone pills right in front of me. And we're sitting there at his patio. And I'm like, Randy, look, in my opinion, before the cock crows, you are going to be arrested. Meaning, before the sun comes up tomorrow morning, you are going to be arrested. In this case, do you understand what I am saying? You know what he says? I don't care, I'm going to bed. He howls, he goes upstairs, and he goes to sleep. True story. We go to the ballet in the Art Center, and I'm getting phone calls now at 10 o'clock at night. Police are raided Randy Thunderdor's house. They're on the scene. They found gun parts all over the house. And I'm like, well, what do you want me to do about it? I'm at the ballet. So we went to the crime scene we went to the search warrant scene around 1 o'clock in the morning. The police were just wrapping up, and they split. So now I got my client arrested for capital murder, his son arrested for capital murder. I already had the statement from the attorney, what I just told you, which is pretty much a quote. And here we are. So flash forward to the following week. The following week, Jim comes to me and says, look, we need to have a meeting in the jail. I'm like, what? We need to have a meeting in the jail between me, you, Randy Thunderdor Jr., Randy Thunderdor Sr. We need to have a meeting in jail. I'm like, as you know, or you all know, there's no, I'm like, Jim, we do not have attorney-client privilege for this conversation. You could get attorney-client privilege for the conversation, but you have to have what's called a joint defense agreement. And really, nobody's got to have a conflict with the other parties, and then you can actually embrace other defense crews and have a joint defense agreement and still maintain attorney-client privilege. But that's not this case. This case is never going to be a joint defense agreement, not with these facts. And so I say, look, there's no attorney-client privilege here, Jim. Well, we need to have a meeting anyway, so meet me over there at 2. Okay. So walk into jail, and here's Father, Son, no Holy Ghost here. Father, Son, Joe, and Jim. The first word out of Senior's mouth, the first thing out of his mouth is, Jim, we got a big problem here. You're the one that told me to get rid of the gun. And Jim says in response to that, I know. Okay, now here's like little kick in the ass number 2 for me. I'm like, why am I hearing this? I didn't want to hear the first time, I didn't want to hear the second time. So now I've got the statement from the attorney with corroboration from the attorney and the client, real time, and I'm like, holy crap. Okay. Not only, okay, let's strike that for a second. Flash forward to getting into the heart and soul of the case. Prosecution case against Randy Tundador Sr. is that he's the tenant that's pissed off. He wants to kill Morrissey because of this landlord-tenant dispute. They're being evicted. He planned the whole thing. He planned the stolen gun being in the truck, which they never could prove that was a staged, definitely the truck and the gun. And that he orchestrated his son, his 24-year-old crack addict son, to do this, to be his henchman, to go in the house and kill Mr. Morrissey. And that, of course, the little spin-off going to the cash machine, that wasn't part of the deal. That was just a greedy son trying to do that because the son was just supposed to go in there and kill everybody and leave no witnesses behind. And the reason we know this is so is because if somebody didn't have criminal intent, and if somebody wasn't trying to, if somebody was totally innocent, they wouldn't be taking a gun, chopping it into pieces, putting it in the wall, the ceiling. That shows criminal intent. That's Judge Ferris used to call it animus ferendi. Where's the animus? Where's the animus? The animus ferendi is guilty mind. So he's got a guilty mind because he chopped this gun into pieces. Why would you do that? Why would you do that? Well, you could do that to protect your son, or you could do that because you're culpable. State attorney goes to trial with this case, and as it turns out, that's their primary piece of evidence because there is no DNA, there are no witnesses, there are no fingerprints, there are no tread marks, foot marks, DNA marks. Junior's DNA is on everything. Junior's DNA is on the gas can. Junior's DNA is on the knife. Junior's DNA is here. Mrs. Morrissey identifies Junior. The primary, you have a question?
No, I was going to say you didn't share the T-shirt part.
Okay, well,
Jim.
I'll get to the T-shirt. Thank
Okay.
you. I got nothing against Senior. Nothing. Nothing. Except he's chopping the gun up, and why would he do that? Make sense? Right? As long as we're talking about ethics here, let's go back to the gun and what the proper response to that gun issue is. Fair enough? Sometime in your life, if you're going to get involved in this business, you're going to have to deal with this issue because it does happen. And the proper response to that, what do I do with this gun, is put the gun back where you found it. Okay? That gun was stolen 3 weeks ago. Your son's in jail for murder. The police think this is a staged theft of the car. Your son did that. Put the gun back where you found it and leave it there. Okay? You got something that's not a murder weapon, but it's involved in the crime. If somebody can make the argument that it's the same Saturday Night Special that misfired. I mean, there's a little jump that the prosecutor have to make, but what you're supposed to do with that kind of stuff is, if the police exercise due diligence in finding that piece of evidence, it's got to be in a place where they can find it if they exercise due diligence. And you can't instruct anyone to destroy evidence. With a little bit of thought here, these things quickly get into, it sounds like accessory after the fact of murder for an attorney to instruct a client to destroy evidence. I don't know if you're taking criminal law yet, but really bad. You're getting into some really slippery slope stuff here. So in that particular case, what I would have said was, put the gun back where you found it. As a lawyer, you can explain why that gun is found in the house. You can explain why. Because Junior's the murderer and Junior put it there. And Junior's living in the same house with Senior. That's how you proceed with this. You don't, okay, so I just want to make it clear on that, because you really got to think long and hard before you advise somebody about evidence and evidence of the crime, and really get jammed up quickly with that kind of stuff. So, correct answer is put it back where you found it. The incorrect answer is you can't have that gun in the house, get rid of the gun. Okay, is that fair enough? All right, so you want me to talk about the t-shirt. Junior, when Junior gets arrested from the Beverly Hills Cafe eating a chicken, a broiled chicken lunch, he gets arrested and the blood splatter is not visible. He gets arrested, he gets booked, the clothing goes in property, and Jim is talking to the detective about his client's arrest. Okay, and they're going over what kind of evidence the police have against Junior, and Jim is just going through this laundry list, no pun intended. And he's got this, you've got that, you've got this, you've got the t-shirt, and the detective's like, what t-shirt? Well, you know the t-shirt he was wearing, you've got the t-shirt, and the detective's like, no, I don't have the t-shirt, but I'll have it in the next 15 minutes. So the t-shirt with the blood splatter was actually given to the police by the defense attorney. Just a little side note. Okay, so I told you that there was really no evidence other than the gun being chopped and mangled, and there's a witness that says, yeah, the gun was put in pieces in the laundry room. Okay, so here we come, and shortly thereafter, I'm the lead counsel on this capital murder death penalty case. I asked for a second chair, which the state of Florida permits. I get a second chair on the case, and we talk about all of these statements that Jim made and how is this going to proceed, because you're in a capital murder death penalty case, right? These things need to come out because they are real defenses. Because it's going to be, you're not guilty, huh? Why'd you chop the gun up and put it all over the house and in the roof and in the rafters? And you say, my lawyer told me to, okay? As you know from case law you've read, that is not a real defense. But I'll tell you what, if you tell that to a jury, they're going to think twice about it. Okay, so you're dealing with death, and you've got somebody that's going to testify, my lawyer told me to get rid of the gun. I have nothing to do with this murder, and my lawyer told me to get rid of the gun. You're good shape. Okay? You're the best shape you're going to be in. Okay? Here's the problem. Big problem. Big problem. Who's going to testify to that? Who is going to testify to that? You ever hear them? Okay. You like pushing them?
No, I was just yelling.
Oh, there you go. You're on now. Come on down here. I'm just kidding. I'm not really fond of the Socratic method, but we figured out good. Okay, so here's the problem. I'm the lead counsel. I can't call myself as a witness. You've got the other attorney who is not going to admit to any of this stuff because after a while, after a while you're going to figure, look, I might even have, forget the bar, I might even get arrested myself here if this stuff comes out. And you've got Mike Satz in a very political case, and politics is a very important part of your job if you're going to be involved in criminal defense or criminal prosecution. even if you don't like politics, you will have to know politics, because that's going to affect the outcome of your cases for sure. And I don't want to get too sidetracked on that, but all right. So you've got a situation where I'm the witness. More ethics. I can't be a material witness and lead counsel at the same time. Fair enough? That's one of the reasons that creates a conflict of interest. So I don't want to really give the case up. This is a great case. I don't want to give the case up. I'm trying to figure out what to do, and it's a very difficult concept. So Randy Cundador writes the judge a letter asking for me to be withdrawn on the case because I am a material witness on this case. The judge called a hearing, and we're there, and he filed a pro se motion that his attorney's a material witness on a murder case. You can imagine how that resonates. But so we're there, and the judge says, Mr. Pappacoda, are you a material witness on this homicide case? And I tell the judge, there is, so when you walk in there, you've got to figure out all the different possibilities of how this would play out. And let's say, for purposes of argument, there's 6 different possibilities of how this would play out. And one of the possibilities is I could be a material witness in the case. And I tell the judge there is a possibility that I would, in fact, be a material witness. Things that happen after the fact on this case. She's like, okay, well, you're off the case. She took the second chair, made him first chair, and she appointed another second chair for Randy Cundador. The second chair attorney, who was my second chair attorney, became the first lead counsel. I had discussions with him as to all of these things, as to both conversations, the one in front of my office and the one in the jail. He wasn't privy to any of that. He wasn't witness to any of that. And now he's the lead counsel, and his point is, well, you know, this is like a really big bombshell here. Maybe it won't come to that. Maybe it won't come to that. And I'm like, well, you're right. Maybe it won't come to that, because there's 6 different possibilities, and that's one of them, but there's, depending how it plays out. So I'm off the case. Cundador goes to trial, and sure enough, the primary evidence from the state prosecutor was that how could he be guilty, or how could he not be guilty when he sliced and diced the gun up and put it all over the house, and why would he do that if he didn't have a criminal mind, a criminal intent, and there's a conspiracy here between him and his son, and why would he do that, why would he do that, why would he do that, with this horrific set of facts of it. In the history of Broward County, this case is probably, certainly within the top 10, but I want to say within the top 3 brutal, ugly cases of all time in Broward County. I mean, that's how significant it was. And of course, the jury, I was not listed as a witness. The state attorney, listening to this little hearing where I'm saying I'm a material witness, the state attorney did not want to depose me because I was not on the defense witness list. The lead counsel did not put me as a witness in the case, and Cundador gets convicted of capital murder. Okay? Little tidbit. Junior made a deal with the state attorney to testify against his father, that it was a conspiracy kind of thing, and Dad orchestrated the whole thing. And the problem with Junior's testimony was that he had vacillated under oath 5 or 6 times. I was the murderer, my dad was the murderer. I was the only one in the house, my dad was a Gatorton. My dad was outside, we had walkie-talkie. It was like all over the board, to the point where he was so incredible you couldn't, it was meaningless. At 6 different, totally diametrically opposed sworn statements. The people in the jail were saying that Junior said he was the murderer, and testimony. Okay, so this is a really important issue. So here we come, and we got a conviction, jury conviction, and what happens now is that the lead, before sentencing, the lead counsel now becomes a Broward County judge. Okay, so my second chair, who now, because the first chair loses the trial, now he becomes a Broward County judge, gets appointed by the governor, and now his second chair is taking over the case. You following this? He's getting ready for sentencing, okay, and his name's Rick, and he's getting ready for sentencing, and I know him very well. We're in the same building, and I'm like, Rick, you know, I was the first lead on this case, and he didn't even know that. I mean, he didn't know. Like, did Randy tell you about the gun? And he's like, what? What gun? What this way? He didn't know about the gun. And I told him about these 2 conversations, and he went nuts. Because he's now going through all the files, and he's going for sentencing on a death case, and none of this stuff came up in the trial, and it should have. And so what he decided to do was to bring it forth at a sentencing hearing, which is called a Spencer hearing. And so here we are back in front of the TV cameras, press, big buzz, media thing. And so now Rick is Rick Rosenbaum. Okay. So Rick is going to bring me in to testify to these facts. Okay. This was sort of like the most difficult thing I've ever had to deal with in law. Because from the time I got off the case until the time I'm going into court to testify about this thing was probably close to 3 years, leading to many, many, many conversations at the dinner table as to, are you going to tell the truth? If you do, you might destroy your friend's life. If you don't tell the truth, someone's going to die. You're going to be unethical, but you're going to destroy your friendship with another attorney. No one's going to believe you. What's going to happen? It's like really intense stuff. Because I know the other attorneys very well for 30 years. Okay. What do you do? What do you do? You know what you're supposed to do, right? Because you're in the ethics class, you're supposed to tell the truth. Don't be so naive to think that lawyers tell the truth. They don't. A lot of times they don't. So, what do you do? Are you going to bury it? Are you going to say, I don't know anything? Are you going to bring it out, try to save your client from getting the death penalty? What do you do? It's not that easy. Probably had 30 or 40 conversations with attorneys over the years with hypotheticals. And surprisingly, many of the attorneys said, forget it. Forget it. Don't bring it up. Don't talk about it. Forget it. And it's really a difficult situation. But see, you're in a difficult place, and you're either going to be one of those people that stands up for what you believe is right, or you're going to be just a chump like the rest of the people that are out there and they're just going to bury it. And I'll tell you what it boiled down to. What it boiled down to is that I would not be able to sleep at night is my client is there saying, Joe, are you going to do the right thing? Are you going to be there for me, Joe? Are you going to be there for me, Joe? And of course, when you're there in that conversation, you're like, yes, Randy, I'll be there for you. And then I flash forward 2 years later, it's coming down to the wire, and it's like, are you going to be there for me, Joe? And what do you do? And I keep saying that because I'm not trying to do like a Marco Rubio thing here, where he keeps repeating himself. It took a long time to figure out what I was going to do. I mean, it took a long time for me to figure out. As long as I didn't have to make a decision like that, you know, do this, do that, what's going to happen with this. Okay, so here I am, the Spencer hearing, in front of the TV cameras in the world. And I get up there and say, Jim met me in front of my office on a Thursday morning at 8:30, and he says, Joe, I fucked up. I hope the police were not on a wire. Randy called me and said, you're not going to believe this. I've got the gun in my closet. And I said, Randy, you can't have the gun. You can't have the gun in your house. You've got to get rid of that gun. And I testified. We were in a meeting in the jail, which is not attorney-client privilege. And Randy says to Jim, we got a problem here. You're the one that told me to get rid of the gun. And Jim says, yes, I know. And that was my testimony. The prosecutor, Tom Coleman, I thought he was going to have a coronary in the courtroom. Okay. He jumps up, puts me under arrest while I'm testifying. And of course, my response to him, because we don't really get along, is, maybe you don't know, Tom, but you don't have arrest authority, so you can't put me under arrest. But what he did is he jumped up and he says, Your Honor, since he's got his detectives ready now, okay? Your Honor, he's not free to leave. Okay, so you know that from constitutional law, that's the caveat phrase you're looking for, because I guess that's why he used it. Are you free to leave? Are you not free to leave? Well, he just said flat out, you're not free to leave. So where I come from, he arrested me. That's my belief. And he tells the judge, read him his rights right now. And the judge is like, are you serious? This is all true. Read him his rights. The judge reads me my rights on the stand. And you say, well, how could he do that? Why would he do that? Okay. Well, the only way he can do that is he's accusing me of perjury, and somehow he thinks he can prove it while I'm sitting there on the stand. He's accusing me of perjury, and he's arresting me at the same time. Okay? So, in the great world of criminal law, back again in criminal law, you've got direct criminal contempt and indirect criminal contempt, and he's saying, there's a contempt right in front of the court right now, real time, while I'm arrested right now. I testify, I get off the stand, the client's crying. Randy Tunador is crying. I leave, and he called me a liar. Because Jim got up and testified before me that none of this happened. None of it happened. Zero. Nothing, nada, zero. So now I've got a situation where he's convicted of capital murder. He's in a death sentence hearing. Good friend of mine is never going to be a good friend of mine ever again the rest of my life. The prosecutor thinks he's arrested me even though he can't arrest me. And Channel 10 is all over the news that I'm a liar, I'm no good, I'm attacking a very well-respected criminal defense attorney in town, and that I am subject to prosecution. Okay, Channel 10 never came to me for this story. They just went to the other attorney board. So I'm a schmuck. I'm going to get arrested. I'm going to get this part. I'm going to get this. I'm going to get that. I'm like, you know what? I'll tell you what. I call my friend, who I've known a long time, Lenny Bierman. Okay, Lenny Bierman is one of the foremost expert polygraphers in the United States, who actually trains polygraphers. He's involved with, he's just an extreme expert. If Lenny Bierman takes your polygraph and he says something, he's better than EF. Okay, so I call Lenny Bierman on the phone, and Lenny says, "Joe, I've been expecting your phone call." So I go in, I typed up a statement of facts, and get a little off topic here, but if you ever have a really difficult case, and your client is saying to you, "This didn't happen, that didn't happen, I swear on a stack of Bibles," and that's going to make or break the case, send them to a polygrapher that's well respected, have them pass that polygraph test, and that is a mighty sword, even though it's not admissible in court. That's a mighty sword. Trust me, it really works well. Okay, so I go for a polygraph test. It takes like 4 hours. He gets his results, and it says, I can't even pull what it says, but they're all, I just should have brought it with me, all different scores, and it's like strong presumption of truthfulness. There's like medium, low, and there's strong presumption. It's got all the scores and all the results, and could be reviewed by an independent. So in there, I've got the statements, I've got conversations with the other attorney, the second chair, and everything that's in. So I'm telling the truth. I give it to the state attorney's office because I value my reputation in the county. The last thing I want is the homicide unit thinking I'm a liar and pulling this kind of crap. So they get the results, and unofficially, I get some feedback that says we know you're telling the truth. We didn't need the polygraph, and we know that you're telling the truth. But officially, it's not that way. So I feel like I did the right thing. I could sleep at night. I think he's still going to get the death penalty. And, the judge gave him the death penalty anyway, so he's on death row. So what's next in this scenario? The bar complaint. The bar complaint is the next thing in the scenario. Here comes the Florida bar. And now what you've got is an issue where one attorney is accusing another attorney of these things, which conservatively would result in disbarment of the attorney, and even worse than that, would result in the attorney possibly being arrested for some kind of accessory or something along those lines, which is even much worse. So the Florida bar is interesting, and I'll tell you why. You know what is supposed to occur, because that's where you're in ethics class. And now you've got a situation where, in order for the Florida bar to proceed with this bar complaint against Jim, the Florida bar has to admit that the trial was affected, which could result in another capital murder trial for Senior. So if they find probable cause that these things occurred, they're giving the defendant more grounds for a new trial. And the prosecutor goes to the Florida bar and tells the Florida bar, you know what? As far as I'm concerned, Joe Pappacoda is a liar, and Jim's a liar, and they're both liars, and those two attorneys conspired together to create this issue, and as far as I'm concerned, they're both liars, even though his unit got my polygraph and they know I'm telling the truth. That's what he tells the Florida bar, and the Florida bar finds no probable cause for this attorney complaint. Okay, so what do we learn from this? Got a little bit of politics. Back, there's our politics word again. You got politics of Mike says, the Florida bar, the prosecutor's office. In order for the Florida bar to actually do something, they're going to hurt the state's case. They're not going to do that. They're not going to hurt the state's case and create another capital murder trial because of Joe Pappacoda says that the state's evidence is all created because of what the attorney told him to do, and therefore it needs a new trial. And you can't give him the death penalty. You can't kill him for this. It's not fair. So you've got the attorney, Jim, who not in trouble with the Florida bar anymore. You've got Joe Pappacoda, who officially is a liar, all over TV and Channel 10 in the news. You've got Randy Tunador, who is just so happy that I testified and told the truth. And my reputation was not really hurt at all. And I could sleep at night. Did I miss anything? Anybody want to ask any questions?
Wasn't them calling you a liar publicly damaging your reputation?
You're going to have to repeat the questions because otherwise it won't pick up.
Sorry.
Okay. The question was, when they called me a liar publicly, didn't that damage my reputation? Okay. Normally it would, but see, that's kind of my reputation anyway. I'm really out there and aggressive and in people's faces. I do things that are really more than novel. I get people to die. I'm pretty much a renegade out there in the universe, and typically when I do something like that, I mean, it's not that big of a shock. But to answer your question, the bigger issue is you're talking about libel per se, libel and slander per se. Really, it's not the calling me a liar; it's the calling me a criminal, which is accident. Okay, if they're gonna call me a liar, I've got to prove damages to my business to go forward with a libel case. But if they're accusing me of being a criminal, I can go forward with a libel case without proving damages. That's just a little towards there. But in any event, I asked Channel 10 to publish a retraction. They didn't do it, and I just like, what am I gonna do? So most of the attorneys that I see all know I told you. It was a little weird there for a while because half the attorneys were like, Joe, you did the right thing, and half the attorneys were, Joe, you're a piece of crap. You were a piece of crap, and I had a tough time there for about a year.
I have two questions.
Go ahead.
First one is, given the whole rigmarole that you went through,
Mm-hmm.
what makes you stay in the field you're in?
Okay. I'll answer that in a couple of different ways. Number one, if you do this right, do this lawyer thing right, you will be the champion of the field you're in, and people will look up to you. And you can always get chinks in the armor, and you will always be on top. And something, an old-timer partner of mine from FDLE from years and years and years and years ago, he told me this statement, and I'll tell you. Okay, so it's something that you can remember, you'll always have to do. If you know you are right, don't ever be afraid of anything. And I've kept that through the years, and that is really what it's all about. If you know you are right, and you're going against a multi-million-dollar conglomerate, and it's you against 100 attorneys, don't be afraid. And you're going to get into situations where you can either be afraid or not be afraid. And you have to go forward and say, this is what I'm going to do, and I'm going to be fine. Second part of your answer is, you guys are like in a petri dish here. You're reading all these cases and case law and stuff where everything's a perfect world and everything, because in order to learn theory, you have to learn pure concepts. There's nothing pure as a concept out there in the universe, really, literally. You're going to run into liars, you're going to run into backstabbers, you're going to run into all these kind of things that you have to use to your, you have to deal with, use to your advantage, and still be superior to those other attorneys. So, in summation is, this is not the first time I've been involved in some kind of major catastrophe like this. This is like the third time, and we don't have enough time for me to go through the other ones, but I kind of have a reputation for doing the unexpected thing. So.
Did you ever talk to the lead chair that took over for you and ask them why they did not put you up as a witness, or why waited until the sentencing portion?
No. That person is now a judge. And to go one step further, I don't know. I know that a lot of these things are in the initial brief that was filed for the capital murder appeal that was just filed a couple of weeks ago. A lot of these things are incorporated in there, but once you get to a point where you've either got a bar complaint issue or a 3850 issue, which is an ineffective assistance of counsel issue, it doesn't really pay to have in-depth conversations with anybody, because they may in fact have to testify themselves at some future date, and you don't want to get involved in there and monkey with their testimony or know in advance what their testimony is going to be or anything like that. So the answer is no. And I don't know if the Florida Bar spoke with that judge or not. I have no idea. I can only tell you that when I tried to call the Florida Bar was really mean to me, really mean and rude to me. And the Florida Bar did not, and I say did not, bring me in for a sworn statement. The Florida Bar did not bring me in for a sworn statement. They brought in the attorney, they brought in the investigator, and they brought in, I don't know if they talked to the judge, but they did not bring me in. Now, how can you go forward with a bar complaint when you don't bring in your primary person? It just defies logic.
Could the Florida Bar, as opposed to the court, consider your polygraph results if they wanted to proceed against legitimate mistake? Can they even look at that?
Everybody has the polygraph. Okay, the polygraph was ultimately submitted in the court file. It's useless because the attorney at the Spencer hearing did not have what's called a Daubert hearing first. A Daubert hearing is relative to the admissibility of, in this case, scientific testing, which is polygraph, which you probably all heard is not admissible in criminal courts. However, somehow magically, with the right foundations laid, polygraphs are admissible in federal court. If you have your Daubert hearing and you laid a proper foundation, you can admit them in the federal criminal court, which is something that Lenny Bierman's been working on for years and years and years. But yeah, everybody had the polygraph results. So, didn't matter. Because common sense, okay? You've got someone that's convicted of capital murder, death penalty, and if you're going to cause any ripples with any of this stuff, you're going to give them more rights to a new trial. And the second time around, he's not going to be convicted of capital murder because the only evidence against him is slicing and dicing the gun up. So they don't want, nobody will go there. Nobody will go there. And Randolph's gonna email you a couple articles that I wrote. One of them is called Pledge and Commitment. And without getting into details about that too much, the concept in there that I call protecting the baby, okay, like a mother protecting a baby. When you get to this level of prosecution, this level of politics, that conviction is like a baby. And if anything comes near you, you get to that baby, you're going to trounce them, you're going to slice them and dice them and get them away from the baby. And that's the analogy. And that's what happened here.
Any other questions? Because I have some when you're done.
Is there anyone that would have told you at the time that you heard the statements to just tell the court or to turn opinion for what he had said?
Oh, that's an excellent question. That's a very good question. Okay, so excellent question, difficult to answer. Okay, if the Florida Bar, as you know, has an ethical rule that says if you see another attorney doing unethical conduct, you need to call the Florida Bar. I am in a capital murder death penalty case. Okay? The Florida Bar rules do not say specifically when you have to make that report. It says you have to make it, but it doesn't say when. It doesn't say you have to make it tomorrow. I mean, you have to make that report tomorrow. No, it says you have to make a report. So this key fact here would have a major impact on the defense aspect of the case, and I am not the lead counsel. And I've made it known to my world what's going on here, and I am not going to call the Florida Bar and tell them about this right now, because this is going to have, the Florida Bar cannot get involved in something that's executory in a criminal homicide death penalty case. In other words, if the Florida Bar got involved in that at that point in time, they would stay that anyway, pending the outcome of this stuff, because they couldn't make a rational decision because it would affect the homicide trial. So yes, I mean, one option would be to call the Florida Bar and make this thing out of it right then and there. Yeah. The client also has rights. The client is the one whose rights are being impinged. The client did not want to make a Florida Bar complaint at that point in time. So now you've got the attorney here and the client there, and the client saying, don't do anything right now. So that's how it played out. I did not get in trouble for not reporting it timely, and had I gotten in trouble, that would have been my response.
Did you see like a noted drop in like your clientele or like people's opinion of you, I guess?
No. Attorney's opinion, yes, for a while. I had attorneys like even so much as like want to spit at me walking in the hallway. But dropping clientele, no. And as far as that goes, a client would probably appreciate you more for telling the truth in that situation.
Daly, do you have a question or not?
I was going to ask a similar question to what Samantha asked. If you could go back and do it over again, would you have reported the misconduct by Jim then, or would you have waited?
If I had to go back and do it again, I think I would have been more hands-on with what was being presented on the defense case than I was, because when I was off the case, I was off on other cases, and really, I would have pressed more for these things to come out during the trial. But, see, I hate to use this, but You can bring a horse to water, but you can't make him drink. So you could tell the attorney about these things, and he's the lead, and you're nothing now, and you can't force him to bring this stuff forward. And to go one step further, because I'm no longer the lead, I cannot tell you that that was not the client's plan with his new attorney to keep that stuff secreted for purposes of appeal and for purposes of ineffective assistance of counsel claims. I cannot tell you that they didn't have that conversation either, because I wasn't there. All I can tell you is that it was not presented as a defense. And in my opinion, it should have, because he would have been found not guilty, in my opinion.
I have several questions for you. Do you remember the name of the staff counsel? Because typically what happens is these go to Tallahassee, and then whatever county it gets sent back, and it's given to the staff counsel. So it would have been the staff counsel in Broward County who had your case and frankly, deep sixed it.
This was out of the Weston field office over here.
Right.
And I do not know the staff counsel because I was never contacted to come in to be a witness.
Okay, well, I can find that out. Another question is, when you were on the case, did you consider actually putting Jim on your witness list, which would have forced him off, with the assumption that he's not going to admit the truth, but he's going to take the fifth? He takes the fifth in front of the jury, assuming that the judge permits that, then that helps you get your client acquitted. Was that ever a consideration? Did you ever weigh that?
No, because right after this happened, I was in front of Judge Imperato, and Judge Imperato was taking me off the case because I was a material witness. So
Okay.
that happened within a week or so. I didn't even have a witness list out at that point in time. It was, I don't want to say it was in the infancy of the case, but I was on that case for about 3 or 4 months, something like that.
Do you think that there was something you told me that you haven't told the students? Do you think that the police might have heard Lewis's Jim's comment? There's a problem with mice in the wall. Yeah.
Repeat the question?
Yeah. Do you think that the police might have been listening in to Jim's comment to your client, which is get rid of the gun?
I should have covered that. There's so many facets here. Okay. What Randolph's referring to is somewhere while this case is ongoing, we're going to court. And I did have a bond hearing, and I fully expected to get my client out, and of course that didn't work. But the detective met me in the hallway, and here's what the detective says to me. Now keep in mind, when the attorney gave me that statement, he says, "Oh, F, I hope the police were not up on a wire." Okay. The detective in the hallway says, "Joe, we know you guys told him to get rid of the gun." And I'm like, time out. There's no you guys anything here. Time out. Have a nice. And I just told him flat out, you're talking to the wrong dude. Okay. I went to see him 5 o'clock at night. I was going to the ballet. I knew you guys were going to hit him that night. And I said, you know, get ready, the police are coming. And that's it. But I don't know how he knew that. I don't know where he got that. And I can't tell you he was not up on a wire, legal or illegal, and that wire just went south. All I can tell you is that detective should not have had that knowledge.
Yeah. Of course, if it was illegal, of course he's not going to mention it. If it's legal, they might have not used it because they would have lost the case. By the way, were you tempted? This is kind of a silly question, but I'm doing it on purpose. When Tom Coleman, the prosecutor, asked the judge to read you your rights, were you tempted to say, "Judge Imprado, would you please read him the ethics rules"? I mean, by the way, are you aware that Tom Coleman's name is on the list? He's applied to be a judge in Broward County. Okay.
No, I did not.
Yeah, his name.
That testimony was pretty. Did somebody hand me that napkin that's on the table? What was going on at that point in time is I've been around longer than a lot of attorneys over there. And Tom Coleman and I don't have a lot of respect for one another, and the entire testimony and cross-examination was adversarial with Tom Coleman, and I was basically, you're an idiot, you know.
Yeah.
I'm telling the truth.
Do you have any doubt that, based on your reading of the case law over the last 30 years, that the Supreme Court is going to reverse this death penalty case?
I think it's going to get reversed,
Yeah.
and I'll tell you why. A couple of reasons. There were a few rulings made in the case that I think were bad. One of them was the judge making a ruling that the conversation in the jail was protected by the attorney-client privilege, when, according to all case law, it's clearly not.
Mm-hmm.
So she didn't consider that testimony at all. And all of the issues pertaining to what I just told you today are included in the direct appeal. There were lots of defense issues that I had planned to do this. I had hired all these experts. One of the issues in the case was that Randy Tunador was not at the crime scene, but he was at Gator Tent, and he got enraged when Junior came back with a fistful of cash and a fistful of crack, and he got enraged and took that crack and lit it in a bonfire, in a tar bonfire. I hired an expert toxicologist to pull up the tar to test it for crack cocaine. The defense attorney didn't use that expert. I hired a police expert to testify as to police procedure, and you can't really keep a crime scene on a search warrant for 3 days. That was all ready to go. He didn't use that expert. I hired another expert. He didn't use that expert. So there's like 4 different things that really went to the heart of the defense case. Really went to the heart. How can you, if there's crack in the tar, how can you piece Randy burning a pile of stuff there if he was actually at the crime scene and going out and buying crack cocaine and all? It doesn't make sense. You don't buy crack cocaine and then burn it in a bonfire. It doesn't make sense. So that part, that aspect went in the direct appeal. And so the direct appeal's out there. If anybody wants to, did I forward that to you? You know? Did I send you that appellate brief?
I think you did. Yeah, oh, no, absolutely you did, yes.
Okay, so all these things are of record, and I know you're not really there yet, but one day you will be. Some of these ineffective assistance of counsel issues, if they occur prior to the direct appeal, and if they're of record prior to the direct appeal, you have to include them in the direct appeal, as opposed to having it later, otherwise you waive your rights. So a lot of that stuff is in the direct appeal.
Any other questions?
The conversation you had in the Spencer hearing that ended up having you removed from it, when the prosecutor accused you basically of perjury on the stand, why weren't you able to at that time say, well, this is why I was removed from the case, because I knew this information?
That did come out. And not only did that come out, the documents came out where the client filed a pro se motion to remove me from the case because I was a material witness for real time when I was removed. So it did come out. The state attorney's office totally ignored it like it didn't exist. The state attorney's office never wanted to take my statement. They don't need me to be on a witness list to take my statement. They could just call me in and say, what's this about you being a material witness? And I would have just told them flat out. But they didn't do that. They didn't want to know. They did not want to know. And it's going back to that concept I told you about protecting the baby. So when you see these couple of articles, that's what I'm referring to there. When you're a lawyer, a lot of times you don't want to know something. Because if you do know something, you have to react differently. And people love to ask me, oh, Joe, you're in this trial, and is your client guilty? Did your client do it? I'm like, I don't know if he did it. Well, did you ask him, did he do it? No. But I want to ask my client if he committed the crime? No. It's not about that. People are not, here's the distinction, okay? People are not found innocent. Okay? People are not found innocent. Innocent is when you get to the nitty-gritty. Did you do it or you didn't do it? Okay? You're found not guilty. That means that the system of American jurisprudence system, they have to prove you guilty beyond a reasonable doubt, playing by the rules. For whatever reason, they cannot do that. Playing by the rules, you are not guilty. It's nothing to do with whether or not you committed a crime. Nothing. And that's it.
I have an observation and a question that you might be able to shed some light on. One of the things that surprises me about this, and I'll make reference to another case, is that Michael Satz, and the answer, by the way, may be who the chief assistant was. The Broward State Attorney's Office, when faced with a conviction, capital case, and it turns out that the judge may have had improper communications with the prosecutor. In fact, the Supreme Court removed the judge. The judge resigned as a judge. My students know about this because they heard the person come in and speak. And the former prosecutor was suspended for 2 years. But when that came to the state attorney's office, Michael Satz hired Bruce Rogo as an expert, and Bruce Rogo counseled him and said, no, you shouldn't defend this conviction. You should just agree. And so that behavior is inconsistent with how that office behaved this time. Now, part of there's a lapse in time, so I think you have different chief assistants. But do you have any thought on that? You know which case I'm talking about, right?
I don't really have a comment on that. All I can tell you is that Satz is a political animal.
Yeah.
And I've known him for years, since 1983.
Yeah.
And the more political a case gets, and I told you this is probably one of the third most heinous murders in Broward County history from the beginning of the century. I can't speak to the Seminoles, but in recent history anyway.
Mm-hmm.
This is a political beast for Mike Satz. And if you ever lost a case like this under Mike Satz's watch, you'd be in deep trouble. And unfortunately, that has ripple effect. And I don't know if any of you watch Court TV, Forensic File, Knives with Wives, and all these things on the crime shows, which incidentally, if you ever do watch TV, and if you ever do have some time on your hands, you really want to watch some of those shows if you're interested in criminal law, because they're fascinating. And that's probably the only thing I watch the only thing we watch are crime.
Well, they did the Tunador case.
They did it in the case, and Fox News, but getting back to Mike Satz, this is pressure. It's rippling down through the system. You're the prosecutor in charge of this thing now. What are you going to do to make sure that your conviction stays? What are you going to do? And do whatever you have to do, because you're going to get fired. And it takes a long time to get to the homicide unit. Like more than 10 years, like 10, 12, 14 years. And you're going to lose the trial, or you're going to make Mike Satz look silly, and your head's going to roll. And this is where you then, a lot of this stuff is common sense. That's it. All he cares about is that you've lost the case. He doesn't care that you should have lost the case. Because one of these articles I'm going to send you is called The Pledge and Commitment. And I think I'm out of time here, but that's a common sense article dealing with how cases start. Police at the crime scene, their perception, their initial conclusions, right on day one. And once they form that opinion, they will push away facts to the contrary. They will push away things that show the guy's innocent, he didn't do the crime. They'll push him away. They will not go in the police reports. Those police reports end up in the state attorney's office, and that becomes the package. And there's a commitment to support those facts. And again, those prosecutors will push away, they will push away anything to the contrary, they'll push it away. And that goes up the line, and you get an arrest warrant, the magistrate judge is looking at that, and it's a steamrolling train. It's just a locomotion. It's in motion, and it's gaining speed, and all the defense facts are pushed away. They're just wicked away, like they don't exist. And that becomes the prosecution. That becomes the baby right there. And where you get into ethics and prosecutorial misconduct is willful refusal to acknowledge defense facts that go to exonerate a person, that to willfully deny them and push them away, like by some reason they could be false, when they're not false. And the prosecutors are supposed to consider all these things. Prosecution has been called the Minister of Justice. Okay, I was a prosecutor for a long time, and I took that seriously. And I dumped a lot of cases that I thought were bad. I dumped a lot of cases that I didn't have authority to dump. And of course, when my supervisor came to me, like, I dumped the case. You didn't have authority. Okay, well, you want to fire me? I mean, I dumped the case. I'll tell you why. You want to fire me, fire me. But you're not supposed to go forward on a case that you know is wrong. This is also raising another interesting point. I know you've passed your time here. Just tell you real briefly. The prosecutorial ethics used to read that a prosecutor will not go forward with a criminal prosecution unless there was, quote, a substantial likelihood of conviction. Okay? Well, what the hell does that mean? But that's a pretty high burden there. That's in the prosecutor's code of ethics. Not the Florida bar ethics, the prosecutor's. Substantial likelihood of conviction. I used that on a couple of occasions to get the state to drop cases. I really did. I mean, you use all your tools. So I went back and looked at that rule like a month ago. You know, they changed the rule. You know what it says now? Prosecutor will not go forward with a criminal prosecution unless there's probable cause, which is a nothing standard. So.
Well, thank you very much.
Don't forget to have an announcement about next class.
Yeah.
All right. Now, next class, we're going to finish, because some of you have recorded the readings, so we're going to finish prosecutorial misconduct. We will then begin next week, of course, with advertising. And I want to mention a couple of things for you. One of the readings, you'll notice, next week, John, I said, fact page. One of the readings includes links to very short 30-second commercials. What I asked you is to pick out, which two do you think are best, which two do you think are worst, and why.
Don't tell people.
And we'll get to that. Also, next time, Monday, class will begin with you doing the evaluation class. So bring your computers. And one of the well, I'm sure it's the way that you got. Oh, here's what it is. I also sent you, because you're going to be, most of you are going to practice in Florida. Florida's rules on advertising and solicitation are very specific. We didn't renumber it. And I sent you the Florida rules. So, and they're easy to read. I mean, you might take some time. When you print those out now, you might as well even have to at some point. Just look at our advertising rules. It's more specific. I'm not going to test you on Florida's rules because they're too specific. I'm testing on the ABA, which is what the Perry tests on. But you've got that. It's on my page, and you've got everything you need for that. By the way, based on the fact that the plantation police department, I live in plantation, I feel really secure. The detectives didn't think to ask for the clothing or the shirt, and it had to be given by the defense lawyer. What does that tell you? I once had a case where I think this guy in the plantation, I think I told you, took $3,000 deposit and returned it. I made the case because the plantation detectives had no idea what they were doing. I got my money back. He got a felony conviction. I really was happy. But good job, right? You see, he is a superior lawyer. And note, in response to your question, it doesn't mean he wasn't afraid. It didn't mean he wasn't concerned with losing clients or reputation, but he did the right thing. He did not let his fear keep him from doing the right thing. And when he was a prosecutor, remember I mentioned to you, the attitude you really have to take, if you want to feel free, he wants to sleep at night, you have to be prepared to be fired or to quit every single day that you're a lawyer. And when he dumped those cases, I used to do the same thing as a prosecutor. There's a case, if you think it's wrong, you drop the case, you nullify the case, and you take the consequences. I was never fired, he was never fired. Meanwhile, there are a bunch of little snowflakes out there prosecuting who are terrified of being fired, so they won't drop it even though it may be unethical. Right? Don't be snowflakes. Right?
I got a question.
Thanks very much. You know, one day, someone's coming at over here giving out cards to people, and you were from Mystic, and we the first 5 minutes class.
All right, are you gonna? I'm a little nervous for tonight, but we'll see.
Oh, why?
Because no one was there last time.
That's a big.
Cool.
Yeah, she's laughing about it.
I'm more nervous about the fact that I don't have anything to talk
Get
about.
away with not having all the way, so.
Thank you.
Yeah, the Supreme Court is going to. In Florida, this is only a slight exaggeration. Almost every capital general case is imposed by the judge. They look who's this way. So you agree or not? I'm just saying that's my observation.
If I'm him, what I would have done is his client's case was damaged by the fact that the attorney told him to hide the gun. Did you tell your son or did you tell junior or senior? So he told senior, and he was representing senior or junior?
I think so.
You represented senior.
That's why I give you the information at the time. What happened was this senior being represented by Joe.
Right.
Jim is representing Junior. But because of the relationship, did you hear that both I and you said that relationship? Senior doesn't call him Jim. Senior calls him Jim because of this relationship they had, even though Jim was not his lawyer.
Right.
So that conversation was not privileged.
Right.
And if it had been privileged, it ceased being privileged the moment, we bring this up, I'd love to have the rest of the class, not to know it, but the moment Jim says destroy the gun, if it had been privileged, none of it was privileged at that point.
Right.
None of it
Right.
at that point. And when in the meeting, where Joe told me that's correct, when the four of them meet, it's not a defense agreement.
Right.
None of that's privileged.
Right.
And Jim, of course, I won't even speculate on Jim. I know Jim, but I'm not going to speculate on what's going through his mind.
Right.
My question told you what I would have done. I would have put you on that witness list.
See, I think, I agree with you, but what I was originally thinking was he should withdraw from the case because
He had to withdraw because he's now with someone was it.
But his client did the motion. That's the only reason it was brought up.
3.7. You don't have to withdraw if you're going to be a witness about something that's controversial.
Right. But
Okay,
what
dispute.
if he was a
Material.
material witness?
Jim comes forward and decides to tell the truth.
Right.
He can't, because he's going to be committing a crime.
Right.
Then there's an argument if the state accepts it where Joe does not have to withdraw. Unlikely. Typically, he's going to have to get out in this case. But the first thing that I would have done is put Jim on the list.
So I guess what I'm struggling with when I want to talk to you is if the client, if
Senior, junior,
if senior
Yeah.
never filed the pro se motion saying that he was a material witness,
ultimately he would have had to get off.
I don't think he would have ever even brought it up, which he should have, in my opinion.
Let me ask you, you're sitting real close to me. Is that your reading of your heart, your gut?
I think
that
he
you're going
feels
to
like,
take for the next 50 years of your life? That's your reading of this man?
No, that's not my reading. But-
your reading of this man?
No, I think he's a great guy because
Then how is your thinking, if that's not your reading of this man, how is that consistent with what you just said?
because he waited for 3 years before he even said anything.
No, he didn't wait for 3 years.
Or
He
didn't
waited
go to
to
counsel.
reply to, what he told me about that, and he and I, you and I might disagree with him on that. Once you're off the case, you're off the case.
Right.
And a lot of people resent, I mean, just try this. Do you have any friends who are married? Yes or no? He doesn't know.
I mean, yeah, yes.
All right. There's-
Not around my age, but yeah.
All right. Try telling them about how to interact with their wives. On a daily basis, call them, listen, have you thought about you should do this for your wife?
Right.
People resent. You know, each lawyer, especially a competent lawyer, a lawyer took over what's a competent lawyer. I won't say exactly yeah, you're competent in this case, but the lawyer took over what's a competent lawyer. That who could have presumed that the lawyer would have done these things?
Right.
Also, for the prosecutor, you mentioned Tom Coleman.
Right.
I met Tom. But if you're a prosecutor, you want to know the moment someone's off.
Oh, that's why he waited until the sentencing hearing to tell the prosecutor.
No, the prosecutor should have contacted him.
Right.
The
So it wasn't
prosecutor didn't
his
want-
duty to tell.
I explained, were you here last class?
Yeah.
Because I thought I told the class, I said, listen, if you're the prosecutor,
Uh-huh.
do you want to know that senior was not involved? Because if you know that, then you can't go against him for capital crime.
Right.
And it was a high publicity case. And what he said, now, I disagree with Joe about Sats. He may be right, I may be wrong.
Mm-hmm.
I think Sats has layers of supervisors between him and the line prosecutor, even homicide.
Mm-hmm.
Sats is not omniscient. He doesn't know everything that goes on in office. And that's why I asked the question about the chief assistant.
Mm-hmm.
When Sats has had Ralph Ray as the chief assistant, or Chuck Morton as the chief assistant, those people were tremendously ethical, and politics didn't go on with Sats. Now, what I heard, the way I choose to interpret what he told us, what Joe told us, is that Coleman wanted to protect him, and that other people think they understand what's going on in Sats' mind. I think I mentioned, if I didn't mention it to this class, I've mentioned it to students over the years, that what they need to do is go to Sats, because they'll find that Sats has no idea. Whenever you're told by a supervisor to do something that they don't agree with, go to Sats, because Sats has no idea the supervisor is telling them this. But most people, I won't mention names, perhaps even some students, let their fear govern them. They're terrified of not being liked. They're terrified that they won't have friends. They're terrified they might be fired. Every decision is not what is right and what is wrong. It's based on, well, what's good for me? What kind of miserable life is that? Be a slave to
Yeah,
I mean, you're either a man or human, I don't know. Man. No, but I'm saying it's historically, you either, well, no, I'm talking about honor. You're either an honorable person or you're not. To be a man and be honorable, which means you stand up, you do what's right, you take the consequences.
Right.
Most people don't achieve that. They let their fears govern them, which is throughout recorded history and beyond. We've had dictators and kings, because most people are effing sheep.
Right.
Typically, America hasn't been, until 2 generations ago, up to World War II, we weren't sheep.
Right.
Obviously, I'm an old man, what do I know? When I view this from the culture, I'm astounded. And I don't think one of my foreign students once, very intelligent, once asked me, what did I think about the Americans claim to be different? And I said, well, I said, that used to be the case. I said, now it's still the case for some, but it's a small minority. Most of us might as well be Europeans right here. We don't have a spine to stand up. And that's true. I mean, the young lady who did this, a lovely young lady, I can't remember, I was mentioning the importance of why I wanted to spend a close-up. And I asked her, would you know about this one project? And I should stop this because that's about everything I'm saying is being recorded.
I don't suppose you know how to stop this, do you?
That he was a Cuban, right? That's what you understood. So my question is, why did he wait so long? Because yeah, I wanted to ask exactly what you asked.
I didn't want to phrase it like